said in India that students enter law schools not by choice but by chance. But this perception seems to be changing with the mushrooming of law schools. The Bar Council of India, the prime regulatory authority of legal education, is aggressively according recognition to the law schools. According to the Law Ministry's 2014-15 annual report, 92 new colleges received affiliation in last 9 months. The cost of a 5-year national law university has shot up as much as rupees 2.47 lakh per year, which is more than any IIT. Well, these lucrative figures offer enough reasons to witness the growing trend of commercialization of the legal education. The first national law school was set up in 1987 in Bangalore as an experiment in imparting value-oriented skilled training. Since then, many more such law schools have come up. However, the larger question remains whether this experiment has succeeded in uplifting the majority of other mediocre law colleges, whether it has managed to bridge the gap between theory and practice, whether the Bar Council of India has done enough in all these years to address these issues. For discussing all these aspects, we now move on to our panel of experts.
Welcome to Simply inTAXicating. Recently, the Union Law Minister, Sadananda Gowda, made a statement that the Indian legal education has always got a raw deal compared to other forms of education. What he probably meant was that the Indian legal education has not got the attention and importance it rightfully deserves. Well, he was quite correct in making these observations. Today, in this episode, we are going to take a stock of the health of Indian legal education and also try to understand the reasons for its current state. The advent of national law schools and the mushrooming of corporate law firms post-liberalization have certainly made law as a sought-after career option. But in a country where there are 1 lakh law graduates passing out every year, isn't this just a tiny dot in the ocean? We are also going to focus on the multi-tier regulatory mechanism which is plaguing the Indian legal education, especially the role of Bar Council of India, which has come under heavy criticism for failing all these years to represent the interest of the students and legal education as a whole. So, the moot question arises, where is our Indian legal education heading towards? Is it that the legal education will be reduced to an island of few hand-picked dynamic national law schools and a vast ocean of mediocrity? If that be the case, then where did we go wrong? Today in our studio, we have a panel of experts. We have Professor K Dixit, then we have Mr. Akash Rukhaiyar from Chase Legal LLP. We also have Mr. Somesh Arora from Amicus Rarus. We are also joined over the telephone by Professor M.R.K.Prasad, who is the HOD of Salgaonkar College in Goa. So Prasad sir, my first question is that what do you think of the overall scenario of the Indian legal education? Where are we right now? Where are we heading towards? In other words, a very important question, has the time come that the Indian legal education is relieved from the control of the Bar Council of India? Can you give us and draw a rather macro picture of the entire situation?
Yeah, I think Sudipto, you have raised a very important question and also a lot of controversy. The biggest problem that the legal education today faces is there are so many bodies to control. There is no single body that controls legal education. I could identify minimum 5 bodies. The first body is primarily the Bar Council of India, which controls all the law schools. Second one is the University Grants Commission. Third one is the state government. Fourth one is if the college is affiliated to a university try to control. And the fifth one is if it is a private educational institution providing legal education, it also has an additional control of the management of that college. So because of these several persons controlling in different directions, there is a lot of confusion and ultimately resulting in deterioration of legal education. The problem is the first one. When we talked about law reform or legal education reform in India, the Bar Council always looks into increasing the number of subjects or what is the standards particularly classrooms, number of students, infrastructure facilities. But they never ever ventured into the quality of legal education. So therefore, the National Law School experimentation, that is what I'm talking, is the Bangalore National Law School in 1980. The idea that was starting that law school is to show that there is a possible way of teaching law in the colleges. So it is basically an alternative to legal education, which was successful and created a hype among the students to take the legal education as a first choice, not as a last choice. So the National Law School experimentation is to a larger extent initially was successful in transforming the legal education as one of the career opportunity for many students. However, after that success, instead of replicating a similar system into all other law colleges, what they tried to do is they put it as an alternative law school. The second problem, what happened with the national law schools were started in each state. Now I think more than 16 law colleges, national law schools were there. Resulted in concentration of resources. The major resources from this country, either from UGC or from the government, are diverted towards these national law schools, which cater not even 1% of the law students. So therefore, there is a huge gap between the national law schools and other law colleges in terms of both human resources and monetary resources. Third reason I look at it is the complete neglect of LLM course. Now, the LLM course is supposed to be providing the teachers to teach the law schools because it's compulsory. Unfortunately, the LLM curriculum, even in the national law schools or some of the premium colleges, are a second-class treatment that was given because their prime focus is only on the LLB course but not on LLM. I feel that we are trying to create a stratification in the legal education. I think the other day I read there are 64 law colleges who were given recognition by the Bar Council to improve legal education. How do you improve legal education without improving the existing law schools just by giving new law colleges permission? Therefore, I strongly believe that the Bar Council of India has neither expertise nor a political will to improve legal education, and they cannot control the legal education or improve the legal education. Therefore, I firmly believe that the Knowledge Commission report that was submitted way back to the central government should be implemented, where the Knowledge Commission was very critical about the role of UGC and Bar Council, says that remove all these authorities and bring all the colleges under one authority. That would have been a way to improve the legal education.
Now, coming back to our panelist in the studio, so I'll start with Professor Dixit. So, after having heard Prasad sir, what are your views, sir? I mean, your years of experience of as a teacher. I mean, what do you think is the current state of the legal education? Where actually we are heading towards?
Broadly, I agree with Professor Prasad, but at the same time, I have my own views because of which the legal education is in doldrums. Unfortunately, in this country, legal education is controlled by those who have nothing to do with legal education. Because I always believe that this is an age of specializations and there is a difference between advocacy. Advocates are equipped to advocate in the courts, judges are equipped to judge in the courts, and teachers are equipped to teach in the classes. The function of teachers are not fit to judge and judges are not fit to teach. Teachers are not fit to become advocate, and advocates are not fit to become teachers. Therefore, teaching should be left to teachers alone. Unfortunately, in this country, legal education is basically controlled by bureaucrats on the one hand, because they are the part of the highest decision-making body of the state law institutes. Judges control the national law schools and advocates control the legal education through Bar Council of India.
So nowhere the teachers are coming into the picture.
No, they don't control. They are being dictated by these three agencies. Now, why am I opposed to this? Because as you know very well, that as far as judiciary and bureaucracy is concerned, their hierarchy is vertical hierarchy. If something has been decided by the Supreme Court, a High Court judge will never say that I refuse to agree with the decision of the Supreme Court simply because I do not agree with it. Similarly, what a chief secretary says, his junior officer cannot say that I do not agree with them. But on the other hand, education is closely connected with the research work, and there cannot be any research and teaching because they are integrally related to each other unless there is freedom to dissent.
So we have the option of the culture of dissenting opinions in the academics.
In academic institutions, I always believe that teacher ought to be controlled, indisciplined. To some extent, they are indisciplined in the sense that when a superior professor speaks something, they must have courage to oppose him. Number two, bureaucratic culture is being introduced in the law schools. Number one, the jobs have become 10 to 5. When I was a teacher in the University of Delhi, which I joined about in 1970, I used to find that teachers were present in the law school from 9 in the morning to 9 in the evening, not 10 to 5. But nowadays, I find them only from 10 to 3 or 4 till the classes are over. So the basic point is 10 to 5 job is not suitable for research work. Teacher must be given freedom whether he wants to study right in the morning at 4. Say for example, I prefer to study at 4 in the morning. The second is, in certain universities and places, annual confidential report has been introduced. Okay. Which means that a teacher cannot oppose the head of the department, even academically. Now recently, the University Grant Commission has insisted that for promotion, certain number of articles must be produced by a teacher. They do not insist about the quality. So what actually is happening, a large number of people getting published spurious articles through some underhand practices. And on the basis of them, they are being promoted.
Mr. Akash, what are your views on this, the current state of the Indian legal education and this overarching powers of the Bar Council of India? Has the time come to dissolve the powers of the Bar Council of India with respect to regulation of the Indian legal education?
There is always a debate between, researching versus employability. Okay, whether, what are we producing these students, law graduates for? Okay. My own sense is that they'll cater to different things. Okay, not every LLB person would become an advocate in the first place. Okay, so therefore we should allow the demand or the market says they say to decide what is good. Who do they need? There is also a debate about. I think I heard something about creating class distinctions and all that, and I don't agree with that analogy that is made. That meritocracy will create divides. Okay, there'll be people, and how you judge merit is a different issue. But if you try to kind of reduce the centers of excellence to the lowest common denominator, because you don't want a class system, then you know what will happen.
What we have to see is, what is our legal system aiming at? Bar Council's role, you said, yes, you need a professional body. After all, every professional body has somebody to take care of that. But legal system or legal education system, as we say, has twin role. One is to be a feeder channel for corporate kind of jobs. Second is for the legal profession. Litigation. Out of 1 lakh people you said who are coming out, about 60% go in other lines. They aim to become members of judicial services, civil services, state civil services, or corporate jobs because they are probably more lucrative to begin with. Legal profession pays only after some work. And now you have certain jobs available with the legal firms. Requirements in two are different. See, out of more than 1,500 legislation which India might have since independence, some are becoming redundant, being weeded out. About 50, 60 are being taught in any legal college. Beyond that, if you want to specialize in any field, you have to learn. A corporate would ideally like to have somebody with a legal background who has more emphasis on various laws, because he will need various commercial and company laws, tax laws. The corporate environment is altogether different. The requirement is to know more and more laws. Here you need specialization, 4 or 5 fields, and you are able to do well. Constitutional law, you've done, okay. Maybe you can be there in the Supreme Court and do well. But in the corporate environment, requirements are different. So firstly, we have to understand that the legal system requires 2 feeder channels, one for professionals, second for corporates and other this thing. And the requirement for the feeder channel for legal profession is quite different from those. There, you will need to know more and more laws. Here, you will need to specialize law and court etiquettes, court presentation and such skills, which can come to you by getting attached with a professional, which is not being done. As far as universities are concerned, they do not even think of it. 15 days, 20 days attachment, that's about it. Compare it with the ICAI, organization which has radically improved its stuff. They always had tough competition. They always said, 5-6% were already clearing, not more than that, because they decided these are going to be the numbers which are going to be in the profession. ICAI organizes for every pass out at least 2 to 3 seminars in every city about the latest developments in the fields of finance, in the field of law. They gear up much better than you do. A law, commercial law, which is taught at the BCom level, in BCom honors course or in other BCom courses, is much better than what is being taught in the law colleges. You need professional organization, but professional organization should act professionally.
So my next question is on the issue that since 1987, in 1987, the first national law school was set up. It was established with a very particular objective that it should play the role of a big brother. It should actually be a role model for the other law colleges. And in India, we have a culture of that if something, any experiment turns out to be successful, then instead of replicating that experiment to the problem, which is to an existing problem, we leave that existing problem as it is, and our entire focus is on that new experiment. So instead of, passing on or conveying the good qualities of that national law school to the existing law colleges, we kept on establishing one after another new national law school, and it's almost a kind of divide which is being now perpetuated. And law school, there are around only 1700 seats in the national law schools, whereas there are around around 1 lakh law students who are passing out every year. So what about them?
There are 2 components of legal education, particularly the law schools. Number 1, the quality of the students, and number 2, the quality of the teachers. And both of them are complementary. Unfortunately, in these national law schools, the emphasis was paid on infrastructure, on the quality of the student, because they have started the examination, entrance tests, etc. And fortunately, in most of the law school, particularly Bangalore, Bhopal, Calcutta, Hyderabad, in these institutions, we get the best students, very bright students. But unfortunately, in these, if you want these law schools to become model law schools, it is necessary that something must be done about the faculty. The quality of teacher has not been emphasized. And as far as state law universities and law institutions are concerned, law institutions are a second-rate part of the educational system. And third layer is constituted by the private law schools. These private law schools are actually not law schools, but they are functioning as business. Say, for example, any other business.
The statistics are speaking for that.
Where the emphasis is on monetary profit, not the improvement on the quality of the education. And I have seen a number of private institutions where some teachers are paid 10,000 rupees per month through some means. They are neither. So if you pay, and I think 10,000 rupees is less than the salary of a car driver. So if you pay 10,000 rupees, if you feed peanuts, you will have monkeys. So this, unfortunately, is the reason that unless you improve the quality of the teachers, there cannot be improvement in the schools. So, of course, the second important thing is do not grant recognition to any law school. Though the BCI, Bar Council of India, is a regulatory body, but as you just now said, that every third day, so why every third day they are giving recognition? Because at the time of recognition, fees is charged from them.
Exactly.
So it is also a business affair as far as the BC Bar Council of India is concerned. So under these circumstances, quality education can be ensured only if deserving institutions are given recognition.
Overseas, okay, the professor publishes that I'm going to, so people apply, whoever are the first, whatever 100 students or whatever in that classroom, that class gets full. Then for the same course, there will be multiple teachers who are offering that course and students apply. So it has to be demand and supply. Okay, it's difficult. It's difficult to think like that, it's a profession, it's not a business and all that. But when I say demand supply, it is not monetary demand and supply. Is there a need quality? Yeah. So quality must be demanded. Quality cannot be forced.
See, the problem in the Indian culture is that teachers are actually first the restriction in the law and the restriction in the Advocates Act that they can't go and appear before the court. Plus, there is hardly any interface between the industry and the academics, which is absolutely the scenario is absolutely different in US.
The culture is that you expect
And it happens.
the teachers to be making compromises. They want to teach, therefore they should teach. Allow money-minded people also to come and teach. If they are good and I'm available for some salary, okay, if someone is willing to hire me, why not? But we are a country of disqualifications.
About the dichotomy which you're talking about, yes, it exists, but it serves a purpose. See where the National Law Colleges students are getting employed. Corporates, good law firms, or maybe high courts and Supreme Court and such places. Not even all high courts. You will get some beautiful National Law College pass outs. What about the mufassil towns? Who are going to feed them? They need lawyers.
Absolutely.
They need hardworking lawyers. So it's the small timers coming from small towns who make a mark there. And lower courts are as important as any higher court. So understand that there's employability even for them. If they work hard and if they are constantly updating their knowledges, they understand the systems and that's about it. So we have to, in the legal, there is a vast space available even for the lower level.
So actually, sir, I'm not referring to whether it is a lower court in a mufassil town or in a small town or it is a lower court in the metropolitan. It's the quality which actually I'm referring to, sir. Okay. There is a divide becoming in terms of quality also. A student who may not have been able to get a seat in those limited 1600 and 1500 seats for the National Law School, but he is very talented. He wants an opportunity, but he doesn't have a forum or a venue to get that exposure. So even if he has the quality, he is not getting an opportunity. So we have heard our panelists. Several aspects of legal education have been touched upon in this discussion. It is clear that traits of any good and balanced legal education does not mean fulfilling the interests only of the industry, but also of the bar, the academics, and the society at large. But unfortunately, the current state of Indian legal education is failing to fulfill these expectations. So, several critical suggestions have been made by our panelists. First, and the most important, is implementing the recommendations of the Knowledge Commission report, which recommends dismantling the multi-tier regulatory mechanism and especially dissolving the powers of the Bar Council of India and to set up an single independent authority which would have much wider representation of academicians as stakeholders. Secondly, to do away with this counterproductive net examination structure and to introduce classroom feedback system which will be more practical and meaningful, which will rather encourage serious law students to join academics as their first preference. Thirdly, to bridge this huge mammoth gap between theory and practice, several training institutes should be set up and compulsory training should be imparted to the law students before they are handed over their law degrees. And this training should also be customized. So a student, if willing to choose bar, that is the profession, or if he is interested in academics, or if he is interested in industry, in joining the industry, the training should be imparted on those terms. Finally, we hope that some of these suggestions should see the light of the day if we are really serious enough to improve the current health of the Indian legal education. After all, any legal education plays a very vital role in shaping up the future of any progressive nation. Thanks for watching.